I'm Ben Meiselas from the MeidasTouch Network. Special Counsel Jack Smith has set a brilliant legal trap to expose Judge Aileen Cannon. It's all going according to plan. Many of you have asked, why hasn't Jack Smith gone to the 11th Circuit Court of Appeals yet to ask to remove Judge Aileen Cannon or ask to reverse some of her decisions? The answer is simple. There has not been an appealable order yet by Judge Aileen Cannon that Special Counsel Jack Smith could immediately take to the 11th Circuit Court of Appeals. You see, Judge Aileen Cannon has created a total and utter mess with her docket. She's invited filings based on apparently things she heard on Fox the night before about the propriety of a Washington, D.C. grand jury. She's granted motions to strike on her own, sua sponte, meaning on her own, of Jack Smith under seal filing. She's accidentally scheduled a CIPA, Classified Information Protection Act, hearing in public, but she would correct her mistakes or try to cover up her mistakes, kind of like Ponzi scheme judging, like she's just covering up prior mistakes, but it's all building up at this point. And I've been talking about here how Jack Smith's been setting this trap before, but it's all coming into focus right now, specifically with these Garcia hearing motions that Special Counsel Jack Smith filed, where it is essentially a mandatory obligation for the district court judge to follow the Supreme Court precedent and 11th Circuit precedent when it comes to potential conflicts of interest, actual or even potential, of lawyers representing multiple defendants or a defendant and multiple witnesses who have adverse interests, where witnesses will be testifying against other witnesses or witnesses will be testifying against defendants or co-defendants, where political action committees, hypothetically, it's actually what's happening here, are paying for representation of multiple people with conflicting interests, or is the interest of the payor, in this case Donald Trump's political action committee, being served. And even where there is a potential for a conflict of interest under the ethical guidelines for lawyering and being a judge, as well as the applicable case law, Judge Cannon can't do nothing about it if there is a clear and present actual or even potential conflict before her. So Special Counsel Jack Smith's like, look, let's do Garcia hearing number 1 for the lawyer representing Donald Trump's co-defendant, Waltine Nauta, Trump's valet and assistant, because that lawyer, Stan Woodward, is not only representing Nauta, but Woodward also represented other witnesses like Yusel Taveras, who previously lied to the grand jury until he fired Stan Woodward and hired independent counsel. Woodward says that he had nothing to do with the testimony by Taveras, but as soon as Taveras got independent counsel, Taveras told the truth. So you have Woodward still representing Waltine Nauta, do a Garcia hearing for Woodward. And then also there is John Irving, the lawyer representing Carlos de Oliveira, Donald Trump's maintenance worker at Mar-a-Lago. And Carlos de Oliveira's lawyer, John Irving, also at one point represented multiple witnesses, although he claims he's no longer representing them. And Special Counsel Jack Smith said these witnesses are going to be testifying against your client, Carlos de Oliveira, John Irving, and there needs to be a Garcia hearing by law. It's not discretionary. It needs to be done by law so that Nauta and Carlos de Oliveira understand the conflicts that exist. They understand that the lawyers may not be representing their best interest, but Donald Trump's best interest, that these lawyers may be actually conflicted or potentially conflicted, and that could harm their defense, as these lawyers may be trying to help Donald Trump or have ulterior motives. That's what you want to flesh out, whether or not that exists at these hearings. And the judge doesn't have the ability to just say, nah, I don't want to do this. You must do this if that is taking place before you. And I think Jack Smith recognized that when he filed for these Garcia hearings, that Donald Trump's lawyers were going to try to be sneaky about it in response. And sure enough, that's what happened. So what did the Trump paid for lawyers for Walty Nauta, Stan Woodward, and John Irving, who's representing Carlos de Oliveira, did? They said, okay, we understand that the law requires these Garcia hearings, but we want to hold them ex parte, meaning we don't want the Department of Justice to even be in the room when questions are being asked of Nauta and de Oliveira about the potential conflicts, or when they're supposed to be instructed that they could have independent counsel and they are aware that independent counsel may advise them differently about their rights than their current counsel. De Oliveira's lawyer, John Irving, and Walty Nauta's lawyer, they were like, we don't want that to be done with the DOJ. Do it ex parte, meaning just, the lawyers being paid for by Donald Trump and Judge Cannon all in a room together. What could go wrong in that situation? And here, Special Counsel Jack Smith's like, you're just making that up. And Judge Cannon, if you do that, you are going to be reversed. The clear precedent says you can't do that. There is no case law to suggest doing this ex parte. This has to be an open adversarial proceeding. So you see where I'm going with this? You see the trap that Jack Smith laid for Judge Cannon? Judge Cannon's always going to do the wrong thing. And specifically here, I think Judge Cannon's going to probably do this ex parte. And that is when you violate the law so flagrantly, like I think Cannon's going to do, that's the appealable order we've all been waiting for. So mark this tape, because I think that is what is going to happen. Now, Judge Cannon can shock me and say, no, we're going to do things the right way, and we're going to hold the Garcia hearing in public in an adversarial. Well, that's great too. If she does that and she now has to follow the law, then the clients, Carlos de Oliveira and Walty Nauta, can be questioned and told by the Department of Justice as well that you can have independent counsel, and you're aware that independent counsel may advise you differently. Are you aware that there could be potential plea negotiations? Are you aware that we were not planning on charging you until you did this? And then they can say, I didn't know that. I didn't know that. By the way, that's what happened with Yusel Taveras. Yusel Taveras, there was an appropriate Garcia hearing that was held because the D.C. judge who had jurisdiction over it, Jeb Boasberg, told Yusel Taveras, you could have independent counsel. And Taveras is like, really? I can do that? Yeah. So then Yusel Taveras got independent counsel, a federal public defender, and then started cooperating, told the truth, and said, yes, Donald Trump and Carlos de Oliveira and Walty Nauta engaged in a conspiracy to have me destroy surveillance footage. And I lied to you, Jack Smith, and I'm sorry about it. I will be a cooperating witness if you don't charge me. And Jack Smith said, fine, we'll enter into a non-prosecution cooperation agreement. We won't prosecute you for lying to the Washington, D.C. grand jury if you testify to what you just said and you testify to the truth. You see, that's what Judge Cannon was trying to probe into, and that's why Donald Trump had his proxies go on Fox to say that the D.C. grand jury was improper, to send the message, I believe, to Judge Cannon to do exactly what she did, which is said, Jack Smith, you need to tell me the propriety of what's going on with this Washington, D.C. grand jury, because her intent is to do the wrong thing, and she doesn't want those. And Trump's lawyers, they don't want the transparency and the things that are actually going on where witnesses are flipping in D.C. to take place. So she invited briefing by Jack Smith to say, tell me about why are you doing this D.C. grand jury? And then Jack Smith's like, oh, well, here's why. Because of these conflicts of interest. And guess what? One of the witnesses who was going to be prosecuted admitted to lying and then pointed the finger at the other co-defendants who are here. And that's why we need to have Garcia hearings, here as well. And you need to do, Judge Cannon, what Judge Jeb Boasberg did. And if not, we're going to the 11th Circuit Court of Appeals. Look at this language that is used here. Look at the cases being cited. Like page 4 of this recent motion, this reply motion, it is telling Judge Cannon, here's what we're about to do to you. We're about to appeal you. Look, this is a case, United States versus Morelli, 1999. When a district court is aware or should be aware of a potential conflict of interest on the part of defendant's attorney, the court must inquire as to whether the defendant is aware of and waives this conflict. Not may, it must do that. Also, it cites the Supreme Court case, Wheat U.S. Section 486 U.S. 161, where the Supreme Court explained a district court must pass on the issue whether or not to allow a waiver of conflict of interest by a criminal defendant, not with the wisdom of hindsight after trial, but it must take place pre-trial. In other words, right now, Judge Cannon, the Supreme Court said that. This is the precedent in United States versus Morelli. Oh, and they want to have this ex parte where it's just the Trump lawyers and you and their client. That doesn't work either. And they cite 11th Circuit precedent requires. And they cite the case, United States v. Register, 182 F3D 820 830, 11th Circuit, 1999. It says, 11th Circuit precedent requires a full-scale adversarial hearing to evaluate a potential conflict. And the court, the 11th Circuit, granted a writ of mandamus after the district court deviated from the, quote, clearly delineated and well-established procedure in Garcia and instead proposed to subject defendants, witnesses, and attorneys to a series of examinations closed to everyone but the judge, a court reporter, and the individual being questioned, finding it is at odds with the principles of the open adversarial system of justice guaranteed by our Constitution. So, Judge, we're ready. We're going to take out a writ. We're going to remove, she doesn't say, Jack Smith doesn't say this, but this is the context. This is how we're going to get rid of you on this case. This is your test number one that we're pretty confident that you are going to fail. So let's see what Judge Cannon does. I think she does the wrong thing. And when she does, let's see what Special Counsel Jack Smith does. But it's clear she has no clue what she's doing other than trying to help Trump. She seems so confused right now. Her docket is a mess. We're seeing things now under seal after she was striking things before. It's what happens when your incompetence is matched or exceeded even by your inexperience. Hey, have you seen patreon.com/MeidasTouch? Check it out. patreon.com/MeidasTouch. And wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.